Okay, so we're going to look at an evaluation of the courts and VCAT. The study design requires you to know strengths and weaknesses of the way courts and VCAT operate to resolve disputes. Firstly, to evaluate the courts, first strength of the courts really is that they can hear all types of cases. The courts are able to hear both criminal and civil matters. They're suitable if there's animosity between the parties due to the adversarial nature of the courts, and decisions made through the courts are binding. However, the adversarial nature can increase tension between the parties as one party wins and the other party loses. Secondly, the courts are formal. Strict rules of evidence and procedure in the courts ensure that all parties are treated in a fair manner. The presence of legal representation ensures that both parties are represented equally and able to argue their case to the best of their abilities. However, courts can be intimidating for some parties, and the high court fees and the need for legal representation are expensive, and that can reduce access if people are unable to afford to go to the courts, and it can also mean that the outcome can depend on how good the lawyer is. If one party is able to afford a better lawyer than the others, then perhaps they'd be more likely to win the case. Thirdly, the courts system enables you to have a jury trial. It means that you're able to have trial by your peers for indictable offences in criminal cases, and juries are optional for civil cases. That ensures that the courts reflect community values. However, juries increase costs and they increase the delays involved, and sometimes juries can be influenced by personal biases or by the media. Next, to evaluate VCAT, the Victorian Civil and Administrative Tribunal. VCAT is much less formal than the courts. Because there's no strict rules of evidence and procedure, that means that it'll be less intimidating for the parties, and parties are encouraged to reach a decision themselves. However, parties, when they go to VCAT, can feel influenced into accepting a decision they're not satisfied with, and tribunals are not suitable for large civil claims, and they're not suitable if there's animosity between the parties. Next, VCAT is faster and cheaper than the courts due to lower fees involved and no legal representation. That allows more people to have their disputes resolved in a timely manner. That should increase access to the legal system, and it reduces the burden on the courts as more cases are able to be heard through VCAT quickly and cheaply. Means that it frees up space in the courts for more serious matters. However, costs in VCAT can escalate if the parties have legal representation, which is allowed for some disputes, generally if the amount claimed is over $10,000, or if the matter is appealed to the courts from VCAT, then obviously that increases the cost and the delays involved. Finally, VCAT is less adversarial than the courts. Parties are encouraged to come to an agreement themselves. There's an extensive use of mediation and compulsory conferences through VCAT. That means that parties who go to VCAT generally are more likely to abide by the decision, particularly if they've reached it through mediation, and they're more likely to be satisfied with the outcome. If the parties cannot reach a compromise in VCAT, then a binding decision can be made by the VCAT member. However, parties can prefer the adversarial nature of the court, particularly if there's anger and animosity towards the other party, and courts obviously are more suitable for criminal cases. And that's it.